All right, it's time for part two of our Civ Pro podcast study guide. Here we go. Demurrer, pleading in the form of motion, raises issues of law, not fact, constitutes general appearance, requests judicial determination as to legal sufficiency of complaint, cannot be brought without first having met and confer on technical grounds, does not have cause of action or one or more elements, or cause of action is missing, can be total or partial. Entire complaint or just one or more causes of action, wrong party named. Brings judicial notice to things that are clear without need of research, common knowledge, or indisputable facts. Does not challenge truthfulness. Assuming allegations true for purpose of demurrer is not an admission. General demurrer lacks subject matter. If any valid cause of action will be overruled. If not curable, case is dismissed. Special demurrer. Technical grounds, lacks capacity, another action pending with same parties, defective joinder, uncertain or ambiguous allegations, failure to allege contract was oral or written, not allowed at all in limited civil cases. If not raised in a timely manner, they're waived. Must contain short statement of grounds, specify clearly and distinctly. If several, each gets a separate paragraph, states whether challenges entire or specific parts. If multiple parties specify which asserted against. Notice of motion, a formal notice of time, date, place of hearing. Memorandum of points and authorities, P&Ms. Points are arguments, authorities are citations to law, typically statutes or case law. They have page limits. Need to be a table of contents or a summary of arguments. Declaration regarding meet and confer attempt, strict time limitations on advance notice of hearing, may require requests for judicial notice and copies of any relevant materials. Filing and serving. Demurrer serve all parties, filed with the court with proof of service, include check for defendant appearance fee, within 30 days of date of service of complaint. Okay. Motion to strike, all or parts, false. Contradicts a document attached or incorporated by reference. Irrelevant. Statements not essential to claim or defendant requests for relief not supported by allegations. Improper. Conflicts with CRC, CCP, or direct order of the court. Cause not recognized in California. Per and personal injury or wrongful death states specific amount damages. Complaint pleads evidentiary facts with conclusions of law. Filed and heard concurrently with demurrer, asking to have offensive portions removed. Must contain when and where hearing will be held and specify parts to strike. Memorandum of points and authorities outlining substantive laws supporting. May require requests for judicial notice and copies of relevant materials. Filing and service, same as demurrer. Motion to strike. SLAP, S-L-A-P-P, strategic lawsuit against public parties. Failed by large organizations to intimidate critics or opponents by making them pay so much money to defend that they will choose to be silent. Failed. I don't think that's the right word. I think it's used by large corporations to intimidate critics or opponents by making them pay so much money to defend that they choose to be silent. Designed to protect whistleblowers. Oh, interesting. Defendant must show a constitutional right to free speech or right to express and redress grievances. Burden shifts to plaintiff to establish that there is probability that plaintiff will prevail at trial. Valid cause of action, competent evidence that there are triable issues of fact. With regard to plaintiff's entitlement to damages, may be filed up to 60 days after service of complaints. Court may allow parties to conduct discovery, prevailing party entitled to cost and attorney fees. Cross-complaint. Only way to seek affirmative relief against plaintiff. Filed at the same time as answer. At later date only with court permission. Completely severable from complaint and answer. Completely severable from complaint and answer. Cross-complaint, cross-defendant. Rows, not does. Okay. Compulsory. Related to subject matter. If not raised, then waived. permissive, completely unrelated to complaint, can join new party if only if claim arises out of same transaction or occurrence as complaint, contains double box caption, becomes new caption for entire action, lower box naming parties to cross complaint, formatted same as complaint, cross defendant has 30 days to respond, filing and service, same as demurrer except if new party to action is named, then special summons and service with special procedures. Appearance is the next section. By filing or attacking or a demurrer or motion to strike. By filing, answer, or attacking or demurrer or motion to strike is considered making a general appearance and submitting to court's assertion of personal jurisdiction. Filing and serving the cross complaint. Served on all parties, mailed, overnight delivery, fax, hand deliver, electronic delivery, filed with the court, need proof of service which is also filed with court. Court needs to check for defendant appearance, done within 30 days. Amending is Chapter 10. Pleading without leave of court. If defendant has not yet answered or filed demurrer before hearing on demurrer, defendant may amend answer within 10 days after filing it, or if plaintiff demurs to answer or before hearing on plaintiff demurrer. So you can change or add facts, change or add parties. With court required leave can, and it says need if time frame fast, add cause of action, add request for punitive damages, ex parte application for correcting spelling names of or naming of does. Manner, redraft in entirety replaces previous, must contain complete statement of allegations. Amendment with just change may be filed, adds to original, does not replace. Defendant must answer or demur unless stipulated to within 30 days to avoid entry of default. How statute of limitations relates to amending pleadings. May not add new defendants after the SOL has run. This why it is so critical to include paragraphs regarding unknown identity of does and their culpability. An amended complaint relates back to filing date of original doc only if the following are true. Based on same facts, seeks recovery for same injuries, refers to same occurrence. If SOL has run prior to filing of amendment to name doe, then will only relate back to filing date of original if all of the following are true. And this is the following stuff that has to be true. Plaintiff was ignorant of true names at the time of filing, original as stated. Original complaint alleged that does were responsible for injury. Original contained a valid cause of action against does. Amendment asserting names of does is based on same general facts. Discovery 11.1. Basic purpose to enable parties to obtain evidence necessary to evaluate their case, to reach resolution before trial, or present best case at trial without surprises. If not done properly, could end up waiving client rights or face sanctions, serves to identify additional witnesses, clarify and narrow issues, dispositive motions, preserve testimony and evidence, promote settlement, prepare parties for trial, scope of discovery, any matter not privileged that is relevant to the subject matter of the action or a motion made in the action that is admissible or is reasonably calculated to lead to the discovery of admissible evidence. Not privileged equals not attorney work product or based on special relationship. Attorney work product protects oral communication between firm members and agents such as investigators, expert consultants, and paralegals, info belonging to the attorney. Absolute privilege against attorneys' mental processes, opinions, etc. Qualified privilege against attorneys' general written work product, witness statements, trade secrets, tax returns, personal records, etc. Can be circumvented if substantial need is shown. Relevance equals depends on what is at issue as defined by pleadings. Informal discovery begins with initial client contact, gather info from client, police records, insurance, crime scene, witnesses, etc. Formal discovery is expensive. Strict rules govern timing, types, responses, amount of types. Assertion privileges might educate the opposition. Tools. Interrogatories. Written questions to be answered under oath. General can be a form, special, specific to case, 35 max unless stipulated or good cause exists or it is supplemental or there has been additional discovery. 3 types of interrogatories. Contention, intended to elicit information about basis of opposing parties' allegations or defenses. What supports their cause. Fact, obtain simple factual information, names, addresses, witnesses, employees, etc., persons with knowledge about the stuff. Document, asks other party to identify documents so they can be sought or inspected later. Pros of discovery. Pros, inexpensive, focus on evidence supporting elements of cause at action at issue, can be used for multiple causes, have potential for great deal of information, do not depend on spontaneous memory. Cons, frequently result in objections to avoid answering, allow for artful drafting responses, do not elevate responding parties' credibility. Do not evaluate responding parties' credibility. Drafting of special interrogatories done on pleading paper with caption titled document must identify propounding party, responding party, and set number. Definitions must be typed in capital letters. Each must be full and complete and separately set forth. Responding party not required to resort to other material in order to complete question. Compound, conjunctive, and distinctive question are not allowed. Subparts are not allowed, i.e. A, B's, and C's. A set may contain only interrogatories, cannot include other requests that are separate or can be asked after RA. Each party has right to two supplemental interrogatories before trial date is initially set and once after each trial setting. Additional discovery needs a declaration, must be signed by an attorney. Copies must be served with a proof of service on all parties to the action, not just to whom directed. Hints for preparing. Outline information designed to obtain. How can I state it clearly, precisely, and not subject to interpretation? Just want to check my time here. Oh, good. Stay within limits. Okay, this is hints for preparing. Outline. Stay within limits. Privileged, relevant, reasonably calculated to leave admissible evidence. These are all questions. Proper format. Follow rules. Responding. Identify responding party. Respond to each question separately. Exercise due diligence to obtain requested information. Number each response consecutively to correspond with question. Provide complete straightforward answers. Responding party signs under penalty of perjury. Attached verification. Answer as literally as possible and provide narrowest possible answer. Hints for responding. Seek a protective order for permission not to answer certain interrogatories. Do nothing, waiving right to object and to putting the onus on the other party to file motion to compel. Respond by answering and or raising objections. Objections. Calls for privileged information, exceeds the scope of discovery, seeks information about the contents of the documents, can only ask for identity and location of documents. Burdensome and oppressive, violates format requirements. Like it contains subparts, exceeds 35 without attaching a declaration for additional discovery, stipulation or court order. Challenging objections. Inadequate responses include incomplete or evasive responses, documents not described with sufficient specificity, any objection that is without merit or too general, motion to compel, Chapter 18.9, required to meet and confer first, within 45 days of receipt of verified responses. Court required to award sanction of prevailing party. Depositions, oral question and answer session under oath, recorded stenographically by certified county recorder, then produced in a form booklet. Plaintiff must wait 20 days after defendant is served with complaint or 20 days after defendant's appearance. Defendant may notice plaintiff disposition as soon as served. Pros, can depose anyone, even people and entities who are not parties. Elicit information in form of testimony and production of documents and tangible things. only way to obtain spontaneous testimony and ask immediate follow-up questions. Allows attorneys to assess if will make a good trial witness, credible, knowledgeable, likable. Can get to commit to a particular story in detail, helpful to impeach later. May ask about the contents of documents. Preserves testimony, may be used at trial if deponent is unavailable. Settlement may be encouraged if intimidated by questioning. Cons can be very expensive. The opposing party must pay for the courier, court reporter, and attorney time, transcript, cost number of pages, may have to subpoena non-parties, may only ask for their personal knowledge and current memory, may simply respond, I can't recall. Can educate the opposition. The opposition. 6 types of depositions: oral testimony of a part only, oral testimony of a part and document production, oral testimony of a non-party witness, oral testimony of a non-party witness with document production, production of business records, no testimony by non-party, witness at a specified time and place, provided to general and written questions. I'm going to stop here and start a new video. No, I'll give 5 more minutes. Rules for depositions in general. Parties, non-parties, natural persons, business entities, nonprofit organizations, and government agencies can be deposed. Depose natural person once, although deposition can be in separate sessions. Natural persons must be deposed: 1, within 75 miles of their residence, 2, in the county where the action was filed, and 150 miles from their residence. Corporation must be deposed: 1, within 75 miles of their principal office, 2, within 150 miles of their designated offices. Notice of taking deposition must contain name of deponent, date, time, and place of deposition, and served at least 10 days prior to deposition. Notice must state if being audio or videotaped. Notice must disclose any ongoing contractual relationship between deposing party, third party financing the litigation, and court reporting agency, and any requirements that they must use that particular court reporting agency. Any specific documents to be produced must be described with reasonable particularity in an attachment or in a notice. When deposing an entity, notice should say person most knowledgeable to testify. Okay. Good to know.